Hey guys, today we're going to talk about IOUs versus loan agreements. I have a lot of clients coming to me asking me to draft IOUs for them. I mean, you don't need a lawyer to draft IOUs because an IOU is simply a piece of paper stating that you owe someone else money. You can download a template. It's a very simple template on the internet. Now, are IOUs enforceable in court? Well, to a certain extent, yes. It merely shows that you borrowed money from someone, but it's not as elaborate as a loan agreement. If the sum is going to be a huge sum, like $50,000, a few $100,000, it is advisable to do a loan agreement as opposed to an IOU. Because an IOU is an informal contract setting out details of a loan and may be used as evidence of a debt of money lent to another person, whereas a loan agreement is a more formal agreement which is appropriate for larger sums of money because it sets out the material terms of the loan, such as the drawdown date. Drawdown date means the date that the loan is disbursed. Okay, usually the loan agreement is usually signed on one day, and the loan monies are disbursed at a later date. So that's called the drawdown date. The loan agreement would also contain conditions precedent. Conditions precedent are matters that the borrower has to satisfy before the loan amount is disbursed. For example, he has to provide security, guarantees, he has to show his ACRA searches if it's a company. The loan agreement will also typically state the purpose of the loan. For example, working capital of a company. It would state the interest payable, default interest rate. Default interest means that if any part of the loan installments are not paid on time, then higher interest would accrue on the loan in addition to the interest payable. It's also typical in loan agreements to state whether repayment is in a lump sum or in tranches. That means in installments, with the interest payable at during each tranche or at the end, right at the end on maturity. Typical loan agreements would also contain an indemnity clause, which will indemnify whereby the borrower has to indemnify the lender against all damages and claims that he suffers as a result of any breach of the loan agreement or non-payment. So if you want to know what's indemnity clause, you can watch the link down below. It essentially means that the borrower has to compensate the lender for all costs it has incurred, including lawyers' fees, in enforcing his rights under the loan agreement. Loan agreements, as opposed to IOUs, would contain a clause on covenants and undertakings. Covenants and undertakings are promises, okay, that you will not do something while the loan is still outstanding, such as the company is not allowed to issue new shares or securities convertible into shares. The company, the borrower, has to notify the lender in writing upon being aware of any event of default, not to use the loan for any other purposes. I've come across cases where after drawdown of the loan by the company, the directors then later use the money for other purposes like personal reasons or whatever, which would be in breach of the terms of the loan agreement. So these are covenants. That means the company and the guarantors have to promise that the loan amount is not used for any other purposes other than the approved purpose. Another covenant for corporate loans would include not declaring dividends to shareholders while the loan is still outstanding, because this would lead to outflow of monies to shareholders instead of the monies being used to repay the lender. Another common undertaking for corporate loans would be for the borrower to furnish monthly income statements and statement of financial positions to the lender so that the lender can monitor the financial position of the borrower during the tenure of the loan. Now we'll go on to events of default, which I shall call EODs, which is a common clause in loan agreements and which you definitely will not see in IOUs. Events of defaults are things, bad things that the borrower has done, okay, which would breach the terms of the loan. For example, a representation or warranty or undertaking by the borrower turns out to be false, or the borrower does not comply with any of its obligations under the loan agreement, including repayment of monies or repayment of interest. And the default is not remedied within a certain period of time, usually 14 or 21 days. It is also common in the event of default clauses to have terms such as bankruptcy or insolvency of the directors, shareholders of the company, or a writ of execution taking place. Also, unlike an IOU, a loan agreement would set out the security for the loan. What is security? Security is collateral for the loan. So it may include a charge over assets, personal guarantees by the directors and shareholders. It could include the assignment and charge of invoices, accounts receivable by the company, a share pledge, or charge over fixed deposits, for example, to a bank. So thanks for watching this video on the differences between an IOU and a loan agreement.